Hey, Kevin, here we are in the Readathon.
Another Readathon.
Yeah, and I've got a couple of, not minor, but not maybe super important things to talk about today.
They're always important things.
That's true. Well, one is something new. Judge Beverly Cannoni has indefinitely extended an order impounding the jury list in the Karen Read trial.
Okay.
Because she believes there's, quote, a real and present risk of harm if the names of the panelists are made public. So she said in her order that the juror, identified as Juror Doe, is, quote, in reasonable fear for their safety and the safety of their family. There's an affidavit that juror filed, and Judge Cannoni's order says that Juror Doe has established good cause to extend the impoundment order until and unless otherwise ordered by the court. Mm-hmm. This order shall not preclude any juror from identifying himself or herself and or from speaking to the public about his or her jury service. Now, you remember on July 8th, Cannoni said 10 days that the impoundment would happen, but now it is indefinite.
Now, remind me, if the trial had been completed, what would the identities of the jury? It was like if it were a mistrial versus if they had come to a verdict. As far as the public availability of the identity of the jurors, like there was a different.
I believe in Massachusetts, the juror lists are made public, but I think that she probably could have impounded it anyway. I mean, I think judges can basically do what they want, right? But typically juror lists are made public in Massachusetts if the case comes to a verdict.
Okay.
But yeah, I actually think this is a good call. I think these jurors should be allowed to remain anonymous if they want to. What do you think? I'm just curious.
Yeah, I'm actually agnostic. I mean, I'm fine. I'm fine with the list being kept confidential. I don't necessarily see a public necessity for identifying the folks, especially when it was a mistrial.
Yeah.
It really, I don't want to say it doesn't affect things one way or the other, but I mean, obviously there is a continued interest in the in the claim that they acquitted on 2 of those charges, but were not allowed to present that. So I mean, what they have to say is interesting, but I don't feel like, they need to be doxxed.
Yeah, no, I agree, because unlike other kinds of public service, right, having a government job or running for office, jurors are impaneled. Like, they get a summons. They are required to show up. They are chosen. It's like a duty that you do as a citizen, but it doesn't necessarily come with, you're also going to be doing a very high profile case where, and I'm just going to say it, in this case, some of the people involved are intimidating. They've created social media accounts that are like harassing people and sharing mis and disinformation about people. I would be very scared if I had been a juror on this case that one of these bananas social media accounts might do some shit to me. I would. I mean, I've seen what they're doing to other people, and it's not okay. So yeah, I think it's probably for the best.
I think these are people who were asked by the state to come in and to do their civic duty, and they did not sign up for that.
Yeah.
And so I'm okay with that.
All right. Well, in other news, the defense has filed a reply to the Commonwealth's opposition of her motion to dismiss. Yeah. As we discussed, the state opposed that motion to dismiss. And it's an interesting reply. I'm not going to get into all of it, but a couple of the interesting points are that the defense points out that the Commonwealth's opposition is notable for what it does not dispute. That according to information from 4 deliberating jurors, the jury had reached a unanimous decision that Ms. Read is not guilty on 2 of the 3 charges pending against her, namely counts 1 and 3. The Commonwealth's insistence that Ms. Read must nonetheless be, quote, forced to run the gauntlet, it says actually, once more is based on several clear fallacies. First, while the defense was given an opportunity to be heard on other issues arising during jury deliberations, i.e. the appropriateness of the Tui Rodriguez instruction, etc., the defense was provided no opportunity to be heard regarding the declaration of a mistrial. So it kind of goes on and basically, it basically says that like we were allowed to be heard. And it also makes this case, by the way, that all the burdens in these cases fall on the Commonwealth and not on the defense. Yeah.
You remind me of the fact that the first time the jury came out and there was a question about a mistrial, the judge did solicit comment from the prosecution and the defense.
The first and the second time.
And then made her own decision, which is to tell them to go back and to continue deliberating.
Right.
But you're right. She, having been so moved by the eloquence of the note, she just on her own did not, declare the mistrial again, but this time without consulting the defense.
Right.
Now, by the way, let's be honest. The defense probably would have seen that as a win, knowing what they know now differently, but they probably would have just said, yes, Your Honor, thumbs up. It's a win. We're taking it.
Right. So basically, they also knock out a couple of the other arguments. They say there's nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to a single question of whether its deadlock is uncertain, but not all counts. Basically, they had argued that would be coercive. Mm-hmm. They also point out that they did not approach the jurors. The jurors approached them, which actually makes me think about something.
Yeah.
I saw something on Twitter. Someone was like, isn't it interesting that the jurors only felt comfortable approaching the defense and not the prosecution? We don't know that they only approach the defense.
That's true.
We don't know that.
That's true.
I would actually hazard a pretty okay guess that the jurors very well could have approached the prosecution as well. Mm-hmm. I mean, the federal investigators also approached the prosecution with their reports, and the prosecution did not use them.
Yeah. And they would probably argue that this is not exculpatory evidence that they would need to turn over under Maryland versus Brady.
Right.
Because they're like, this doesn't speak to her guilt or innocence, just speaks to what that jury thought, which is kind of silly.
Well, that's the whole thing. If you were a juror and your claim is, I was extremely confused when the mistrial was declared and we were hustled onto the bus, we thought we were going to have a chance to talk and say something else, and then we didn't. Mm-hmm. What side would you approach?
I mean, I would be approaching the defense, obviously, yeah.
I would probably approach I'd probably approach the prosecution.
Oh, I would.
I'd probably approach both.
Oh, yeah.
But like, I wouldn't just approach one side. I'd approach both sides. Anyway, so.
Well, two of the jurors, as you recall, two of the jurors did not approach directly. Right. It was people that were acquaintances and said this is what they said.
Correct.
And it kind of corroborated what other jurors said anyway. Yada
and some
yada.
people are saying the number is 5, not 4. I don't know where that 5th one comes from, but I've seen Turtle Boy say that. Anyway, so it'd
be very easy to find out what the 12 jurors came to just by asking the 12 jurors.
Exactly. Polling them or asking them to fill out the form or showing us the form.
Why does this take more than 1 minute to determine that would be the course of action?
I don't know. All right, another small piece of news, but true piece of news. Karen Reed is selling her Mansfield home.
Oh, okay.
There's an article in the Globe about it, lots of places about it. This, my friend, is the actual Zillow listing for Karen Reed's
two-car
garage. Very good taste.
Oh, nice interior.
The kitchen could use some updates. I'm just going to throw it out there. I'll show you the kitchen. Looks like it's got some outdated granite, and the stove has a really awkward placement there in the corner.
Oh, in the corner.
With a microwave and a shovel. I'm just going to say...
Do they even make an oven that is... Okay, never mind.
I'm just going to say it does not look like Karen Reed is a cook. This is not exactly a chef's kitchen. However...
No, this looks like new construction.
Look at this nice walkout basement with the beams. Isn't that cozy?
Yeah. Remind us how she made her money. She's in finance?
Yeah, she worked in finance. And, she was I guess did a short adjunct contract as also a professor. But she's selling her house for $850,000.
Do you think she needs the money?
This is the question.
I would imagine she needs money.
The trolls, they were like, she's now bankrupt because of her. It's like, we don't. I love it when people say stuff we don't fucking know. And even the pro Karen people are like, poor Karen Reed. She's lost her job. She's lost this. We don't know anything. We don't know that she hasn't sold her life rights for millions of dollars. We don't know anything about her personal financial situation. There's no way for us to fucking know that. She very well just may want to move because people keep driving by her damn house. Right?
Yeah.
That also might be why the Alberts moved. We don't know. We don't know. Yeah, it's super sus.
Did you refinish the basement with a new layer of concrete?
I don't know. It's super sus that, the way that their, thing went down because, they have family or whatever right in the neighborhood. They moved to a whole different town. But she might just they may have moved because they were tired of people rolling by their house. But she might be moving because she doesn't want to be Karen Reed in Mansfield anymore. She wants privacy. Maybe she wants to live in a house in a town where the tax records aren't published online like they are in New England. Who knows?
Yeah. But undoubtedly, she has a large legal bill when she has these top attorneys and you have a trial that goes on for 2 months.
Yeah.
Especially one of your attorneys is commuting from California.
Yes.
Like you're paying for all of that.
Yes.
Yeah.
Which brings me to the final thing I wanted to talk about on this readathon. Homicide Los Angeles on Netflix.
Yes.
New series on Netflix. And Kevin, who is featured in that series?
Alan Jackson.
What?
Not the singer Alan Jackson, the attorney Alan Jackson, because he was originally, as folks may remember, a prosecutor in L.A.
That's right.
So he's there in his role talking about some of the cases that he prosecuted.
Including the Phil Spector case.
Was he on Phil Spector?
Yeah. He prosecuted the Phil Spector case,
okay.
And he was extremely young. And according to Alan Jackson, it was the first high-profile celebrity case that was successfully prosecuted in 40 years. He was extremely young. He was a brand new, like, cub prosecutor. There's footage of him giving a press conference. He's like a baby.
It's just like, I keep thinking like OJ was like the prosecutor's office Vietnam.
Yeah.
They like just couldn't win one after that. Yeah. Wasn't there also another attorney who we recognized?
Another attorney recognized, Mr. John Lewin, who we recognize from The Jinx Part 2.
Part 2.
One of the only prosecutors I have ever seen in a documentary that I like straight up loved. He's so fucking funny. You remember how funny John Lewin was?
He was. Not as funny as those twins, but yeah.
No, the twins were great. But the funniest thing about John Lewin was his acknowledgement of how funny Robert Durst is or was. Remember what Robert Durst...
This is a paid phone call from... Bob! Yeah.
Do you remember how funny Robert Durst was the first time he met John Lewin? Remember what he said to him?
Something about, I'm surprised there's that many cold cases to keep you busy or something like that.
He's like, I'm the prosecutor for the Los Angeles cold case unit. And he's like, I'm surprised there's enough work for that to be a full-time job.
Isn't that what I just said? But with other words?
Like that. It was so funny. Anyway, so watch Homicide Los Angeles if you want to see Alan Jackson. He talks in real time, like today, as at the Alan Jackson we know. But you also get to see him as a baby lawyer, and it's very entertaining. So anyway, that's the small things I wanted to discuss in the readathon today. I know it's been a couple of days, but you know what Monday is, Kevin?
What is Monday? The 22nd.
Yes, and what is the 22nd?
It is the conference hearing about rescheduling a trial.
It is the status hearing.
Status hearing, okay.
Yes, and so we are going to hear, ostensibly, we'll have another update for you. We'll see what happens on Monday in the Karen Read case. It should be interesting. And of course, you'll hear from us before then if anything happens, which it could, because,
We always be reading.
Final question, Kevin.
Yeah.
What'd you think of Turtle Boy?
Turtle Boy he's an interesting guy.
Yeah.
He's not afraid to admit he's a dick.
No, he's not.
But he's also, but that doesn't mean he's wrong.
Yeah, and by the way, we did look up that statue in Worcester.
The Turtle Boy statue.
It 100%
looks like this naked young man is sticking it in to doggy style on a turtle.
If you haven't looked it up, look up the Turtle Boy statue in Worcester. Aiden Carney was not exaggerating. That boy is fucking that turtle.
But you also have to look for the photo of the side view.
It's worse. It's worse. You think it's just like the angle?
No, look at the side.
It's worse from the side. If it's possible, it's worse. And by the way, you did discover a different statue in Worcester, a much more innocent statue that could have been
this boy and a dolphin.
That the blog could have been Dolphin Boy, but no.
No, the Turtle Boy.
All right, well, that does it for this edition of the Readathon.
He's a reptile fucker.
We'll be back if there's more to report, and it was nice talking to you.
Partners in Crime Media.